Some strange goings on in Iowa today. In case you haven't heard, I'm sure most of you probably have, but the Iowa Supreme Court ruled today that the long-standing 170-year-old definition of marriage in Iowa violates their state constitution. And apparently all of the previous Supreme Courts up until this point were unaware of this fact, but now we know, because of these 7 unelected judges, that the definition of marriage has been in violation of the state constitution for 170 years now. So, there are so many problems with this that I thought it would be important to make a video about it. And today I'm going to give you a little civics lesson. We live in a constitutional republic. That has been our form of government from our founding, and it has served us well to this point. What that means is, as a republic, we get to elect representatives who go off to our state capital or to the federal capital to represent us in making legislation. Our legislators represent us, so we have a say in the process because they run on platforms, they have positions, and we know those prior to the election, and we can put forward our say and say, all right, I like what this guy stands for, I'm going to vote for him. Our vote counts, and it has an effect in what gets passed. As a constitutional republic, that means that there is a constitution above every law, that every law must comply with, and every state has their own constitution. It's like the Uber law, and it was written by the original legislators, and it can be amended by the people, and we also have a federal constitution. And everything must comply with this. Anyone who serves in government pledges to protect and defend the Constitution. We in America have a 3-tiered government. We have 3 branches of government. And there is a clear and distinct separation of powers. Each branch has its own functionality, and it is restricted by the Constitution, by the federal Constitution, to those roles. We have the legislative branch, the judicial branch, and the executive branch. The legislative branch, they are our representatives, and they make the laws on our behalf. They represent we the people, and they write laws. The executive branch is charged with executing the laws that were written by the legislative branch. And the judicial branch makes sure that any laws complies with the Constitution, which is the Uber law, and just basically applies the laws that are written by the legislative branch. And it is really important that there is a clear separation of powers. What happened in Iowa today is a very tragic example of judicial activism. You've probably heard that term before. But what it means is the judges who are unelected, keep that in mind, they are unelected. So they weren't running on a platform. You had no say in them getting there other than by voting for your governor. These people were appointed by the governor, and they are there simply to apply the law. If they are acting as a legislative body, what they essentially have become is an oligarchy. If you look that term up, you'll see it's basically when a small group of people rule in a dictatorial fashion. So essentially, these people have elevated themselves to an oligarchy, saying that instead of applying the laws that were written by the legislative branch, that they are going to themselves make laws from the bench, not having been put there by the people. This is what happened in Iowa today, because if they were really doing their job, they would recognize that there is nothing different today than for the last 170 years. The definition of marriage as the union between a man and a woman is just as constitutional today as it has been from the beginning. Nothing has changed other than the judges themselves have an opinion that they don't like the way the Constitution was written. They don't like the laws that were put in place by the legislator, so they have chosen to use their power to undercut those laws and to get rid of them. So they have arbitrarily chosen that the current definition of marriage and the definition that has been in place, as I said, for 170 years is somehow unconstitutional. when it has been considered constitutional and clearly has been from the beginning. But what is their basis for this? They say it violates some equal protections clause. And this raises a big question. Do we get our rights as individuals or as based upon the group or a group that we affiliate ourselves with? Do I get my right as being an American citizen, or do I get my right because I'm a white person or a male or a heterosexual? How do I get my right? Clearly, the answer is we get our rights as individuals. Because really, anyone in Iowa can get married under the definition of marriage as it has existed for 170 years. The issue is homosexuals don't like that definition of marriage. It's not that somehow they're being denied a right that others have, because let me break this down. The definition of marriage is the union between one man and one woman, and there are certain stipulations that are universally applied. For example, you have to marry one other person. Can't be two or three. That other person has to be of the opposite gender. They have to be a certain age, and they also can't be a close relative. Now, this definition and these stipulations are universally applied, meaning that they don't ask you what's your race, what's your gender, what's your age. It's just everyone can get married based upon this definition. So it's universally applied. Now, each of those stipulations, though, prevents some group out there from being able to marry the person they want to. For example, the restriction to one spouse. We've seen before that there are groups such as fundamentalist Mormons who believe in polygamy, and this prevents them from having their marriages recognized legally in the United States. Of course, the clause saying that your spouse has to be of a legal age, that prevents some people from possibly marrying who they want to. If an 18-year-old guy wants to marry his 15-year-old girlfriend, he might not be able to do that because it violates the law, and most states have, in fact, I think all states have some kind of a minimum age. But it's not as if, in these cases, the people are being somehow denied a right that others have, because nobody has the right to marry a 15-year-old. It's not that this guy has been singled out and he's been told, you can't marry a 15-year-old, but other people can. In the same way, homosexuals that say they're being denied an equal right, if we say that rights are applied as individuals, then nobody has the right to marry someone of their same gender. So it's not like this person's being targeted and denied an equal right. The issue is they don't like the definition of marriage. So that blows away any theory from a legal standpoint that they're being denied some equal right, because it's applied universally. If you want to marry your cousin, you're not going to be able to do it. There are laws against that. But that doesn't mean that you're being denied a right because you can't marry the person you want to. Nobody can marry their cousin. And it goes the same with gender. And I want to pose to you a completely plausible situation. If we are going to allow our judicial branch of government to act as a legislature and arbitrarily redefine laws and just throw things out on a whim like this that have been in place for more than a century, then what happens if in Utah, where we recently saw Warren Jeffs, this guy was the leader of, or actually it might have been Texas, I don't know, regardless of the state, this guy was the leader of a fundamental Latter-day Saints church. And they were basically having polygamous marriages under the radar. And some of the people involved, some of the girls were underage. And it was shut down. The feds went in there and broke that thing up. What would happen if in his state he had sympathetic judges on the Supreme Court, and some organization filed a lawsuit on their behalf saying that they were being denied equal rights because they can't marry who they want to under the current definition of marriage. And if he had sympathetic judges, they could arbitrarily just redefine marriage, saying that the definition of marriage that has been in effect from the beginning is now unconstitutional because it prevents Warren Jeffs from having a 14-year-old bride and another 20-year-old bride, and however many he had. It prevents the polygamy and the underage marriage. So they have arbitrarily decided that the current definition of marriage violates the Constitution under some equal protections clause because he can't marry who he wants, but other people can marry who they want. And that's the basis of it. You can't tell me that there isn't an exact parallel between that and what's happened in Iowa today. It's the same thing.